Good afternoon. Monica Miller here, Legal Director and Senior Counsel for the American Humanist Association. This is Legal Tuesdays, where I answer your questions about separation of church and state. The first question I will get to is from Rachel Combe, and she says that I think many of us are anxious to know what the Espinoza versus Montana ruling means for future rulings related to church, state, and school, and are there any silver linings for us? So this is, we've actually addressed the Espinoza decision in a recent Humanist Legal Society event that you can find on our YouTube channel or on the American Humanist Association website. You can find it through just dropping down and finding the Humanist Legal Society. We submitted an amicus brief, and I've spoken about it at several speaking events, including the AHA's annual conference. So you can check that out, also available on our website. But to answer the sort of more nuanced question about the recent Supreme Court ruling, so I'm actually going to include the decisions that involved the ministerial exception. So those were two cases that were joint involving private school, Catholic school teachers who had been fired on grounds that would otherwise have been illegal, but that the Supreme Court said fall under this exception that they'd only recognized once before, called the ministerial exception, the ministerial exemption, which says that when a church or now private school, private Catholic school, or parochial school hires people that are central to their mission, central to their religion, like a priest, that the religion that has hired them gets to choose, who they're hiring when it comes to something core to the religion. The Supreme Court basically in these recent rulings expanded that definition so broadly that they were basically giving Catholic schools license to discriminate in ways that really just sort of eats up the Establishment Clause. One big sort of picture silver lining I see here is that some of the entities that lost this summer, I would say, weren't atheists. The losers in the ministerial exception cases, for instance, were Catholic school teachers. And I think one silver lining is that other stakeholders, besides atheists, besides non-Christians, are starting to see the problems with church-state separation when they're not separated. They're seeing the Supreme Court bend over backwards to accommodate some religions or some people within the religions and not others. And so in this instance, I think one silver lining is that even bona fide Catholic, people who want to be teachers might end up going to teach a public school or somewhere else where they will have more protection. So in the cases that were handed down this summer, one teacher at a Catholic school was terminated because she had to take a medical leave for having breast cancer, and the other one was had a viable claim under the Age Discrimination Act for being replaced with someone younger. These are generally accepted laws. The teachers in question were teachers for all grades, so it wasn't just a religion teacher, it wasn't a minister. They taught art, math, science, all of the classes within the Catholic school, religion just being one of them. And the court basically said that those teachers were tantamount to ministers and therefore could be terminated by the religious school. And this exception is so all-encompassing that it actually says federal courts can't even look into the propriety of the termination itself. They're barred by this exemption. So it's a very it's an interesting ruling because, like I said, the losers are not atheists. They're Catholic school teachers. As far as Espinoza goes, I think that ruling, and again, I talked in more detail about this in our Humanist Legal Society event and at the AHA's annual conference this year. But there's silver linings too, and I think for the Espinoza case, I think it's a wake-up call. It really does flip the Establishment Clause, separation of church and state, on its head. And it basically says that whenever the government creates a program in which there are recipients that are private but not religious, that the government also has to give that benefit to religion. And there might be some caveats, but the ruling doesn't really specify what those are. And that's a really dangerous precedent. And I think there's definitely a lot of outspoken religious groups the Joint Baptist Committee being one of them, but that say this is a really big problem, that the government can't expect to give religious groups money without strings attached, those strings being laws or regulations. And we know that the churches are going to claim and seek exemptions from those generally applicable rules, but they should be cautious. They should be aware of the fact that once they get government money, that there are strings attached. And do you really want the government shaping or having any say in how your religion teaches its message? So I guess, yes, that is all I have time for today, but I will talk to you in the next segment of Legal Tuesdays.